I'd like to welcome our guests online. And we have two engagements today. The first engagement is with representatives from Relatives for Justice. And we have Professor Emeritus Bill Ralston, Chairperson, Claire Hackett, Vice Chairperson, Irati Aliyaga Iesta, I hope that's reasonably okay, Legacy Caseworker, and Mark Thompson, CEO. On behalf of the committee, I would like to welcome you all to today's meeting. Before we begin, I just have to explain some limitations about parliamentary practice and the practice of the Houses as regards reference you may make to other persons in your evidence. The evidence of witnesses physically present or who give evidence from within the parliamentary precincts is protected pursuant to both the Constitution and statute by absolute privilege. However, witnesses and participants who are asked to give evidence from a location outside the parliamentary precincts are asked to note that they may not benefit from the same level of immunity from legal proceedings as a witness giving evidence from within the precincts does, and may consider it appropriate to take legal advice. Witnesses are asked to note that only evidence connected with the subject matter of these proceedings should be given and should respect directions given by the Chair and the parliamentary practice to the effect that where possible, they should neither criticise nor make charges against any person, persons or entity by name or in such a way as to make him or her identifiable or otherwise engage in speech that might be regarded as damaging to that person's or the entity's good name. Members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against a person outside the House or an official either by name or in such a way as to make him or her identifiable. So I now call on Mr. Ralston to make his opening statement, please. And thank you.
Yes, thank you. We'd like first to thank the committee for today's invitation and also to acknowledge your steadfast work in promoting and protecting the Good Friday Agreement, including your work towards realising the full potential of the agreement by seeking its full implementation. Against the backdrop of almost 4 decades of violence in which over 3,600 people lost their lives and tens of thousands were physically and psychologically injured, the agreement was finally signed. It was welcomed by the majority of those who bore the brunt of the violence, those bereaved and injured. The Good Friday Agreement heralded a new era, and not least an era of hope. It made provisions for rights, equality, justice, and much more. The subsequent signing of the Human Rights Act 1998 as an integral part of the agreement incorporated into domestic UK law the European Convention on Human Rights. This, largely along with the end of violence, provided bereaved relatives a space to reflect and an agency to seek redress. It provided a human rights-based framework which had hitherto been denied. Such agency enabled families to use the law, assert their rights and seek justice. It signalled a potential end to impunity. And then in 2010, the appointment of an Attorney General further added to that rights framework. Now, in the 2.5 decades since the signing of the Good Friday Agreement, the UK response to legacy issues, that is, outstanding issues of truth and justice arising from the conflict, has been shameful. Overall, its approach is self-serving. They have deliberately frustrated due process and flouted the law. In respect of its own role in the conflict, the UK has determined a policy of denial, delay and obfuscation. Paralleling this has been the systematic destruction of evidence by state authorities and the deliberate withholding of resources in order to thwart justice. The use, or rather misuse, of the term national security, public interest immunity certificates, and even secret courts, what they call closed material procedures, that lock out families and their legal representatives, are all a regular occurrence. The result is that for decades, is that matters drag on for decades while relatives are waiting for justice. The arbitrary assertion of the national security veto by the UK after the signing of the Stormont House Agreement on legacy was typically in keeping with their approach. It was described then by Irish Government Minister Charlie Flanagan as, quote, a smothering blanket of national security. It was there to conceal evidence. We now know that as the Stormont House Agreement was being negotiated by the Northern Ireland Office, the Northern Ireland Office was secretly depositing in archives at Kew Gardens files relating to controversial killings by the British Army, with orders prohibiting their release for decades. Some of these files related to the killing of children by plastic bullets. Such sleight of hand was also evident in the passage of the Northern Ireland Troubles, Legacy and Reconciliation Bill, when Lord Kane made amendments on inquests once he realised coroners had made efforts to expedite hearings to ensure completion before the law became operational. His amendment assured that the majority of inquests will not be completed. The UK government claims that the current system doesn't work, takes far too long, and doesn't deliver the right outcomes, including that there's no agreed way forward on legacy. It says, therefore, that its legacy bill is a new departure, but this is an exercise in breathtaking hypocrisy. In reality, the UK are bad faith actors with vested interests. With the Northern Ireland Troubles, Legacy and Reconciliation Bill now enacted into law, the UK has simply amalgamated all of the underhanded tactics used against families seeking justice into one act and one body, the Independent Commission for Reconciliation and Information Recovery, which is anything but independent. It is our view that the Act breaches Articles 2 and 3 of the European Convention on Human Rights and hollows out key provisions within and directly related to the Good Friday Agreement. It sounds like a lot, but let me give you 12 bullet points here which itemize our problems with our issues with the legislation. 1, the ICRIR, that's the Independent Commission, will not conduct Article 2 compliant investigations, but rather will perform desktop reviews. 2, families will have no input save for victim impact statements, which in truth have no standing. 3, families will not be afforded rights of representation. 4, there will be no openness or transparency. 5, all matters of review will be conducted in secret. 6, families may not even be told if an individual responsible for and or involved in the killing of their loved one has applied for or been granted immunity or amnesty. 7, once amnesty is granted, there can be no investigation, even should this act be repealed at a later stage. 8, a British Secretary of State will have ultimate control as the Act confers all key powers to that office. This includes determining who is granted amnesty or immunity and who is not, and determining which cases are to be prioritised and reviewed. 9, reviews will not examine thematic patterns and linked cases. 10, the Act imposes a legal obligation on the Independent Commission that they must grant immunity from prosecution when, quote, A, person has requested such immunity, and B, where the person has provided an account which is true to the best of their knowledge and belief, and C, where the panel is satisfied the conduct described would appear to expose the person to prosecution for a serious troubles-related offence. The threshold for obtaining immunity, therefore, is quite clear and arguably constitutes an amnesty. 11, in this regard, the Act disapplies the terms of the Good Friday Agreement in respect of sentencing within a court of law of a person found to have been convicted of a conflict-related offence. Excuse me. And finally, 12, one of the main stated objectives of this Act is to protect British soldiers from investigation. Last week, the challenge by families against this Act concluded in the Belfast High Court. Arguably, this is the single most important legal challenge in decades. Once judgment is delivered, whichever side wins or loses, there will inevitably be appeals, and thereafter it will be appealed to the UK Supreme Court. This will take considerable time over the coming years. Only then could this matter go to the European Court of Human Rights. This is a time families cannot afford. The age profile of relatives means that many will die waiting. The heartache and additional harms continue, causing intergenerational trauma, torturing families whose lives have been turned upside down and who have been failed time after time after time. The sweeping and systematic breaches within this Act with respect to the European Commission on Human Rights, the Good Friday Agreement and the Human Rights Act that impact all victims place a responsibility on the Irish government, we would argue, to act. Having patiently and in good faith tried every conceivable diplomatic effort to avoid the passing of this Act by the British government, we believe there is only one position left, and that is for the Irish government to initiate an interstate case challenging the Act. This too would be a humanitarian issue in terms of expediting the case in Strasbourg. Many leading legal experts believe that such a challenge would be successful. We acknowledge that ultimately this is a political decision, a decision that would have widespread support here and internationally. The British Labour Party has committed to repealing the Act if it is to come to power in the next British general election. Taking an interstate case would certainly add to ensuring that this commitment would be honoured. There is an attempt through this Act to extinguish the rights that flow from and hopes envisaged in the Good Friday Agreement. Collectively, we should all play a role in ensuring those rights are assured and hope remains. Families, NGOs, lawyers, academics, civil society, and countless others, including your distinguished committee, are all playing their part. Families are never giving up. As a signatory and guarantor of the Good Friday Agreement and the Stormont House Agreement, we believe it's time for the Irish government to once again play its part.
Thank you. Thank you very much for your opening remarks. I neglected to say this to our members here, but the rotation will be, because we have until 11 o'clock in this section, we take Sinn Féin, Fianna Fáil, Fine Gael, SDLP, Independents, and so on. And as people identify themselves online and as they come in, we'll give you names to that rotation. So I understand John Finucane is the first speaker for Sinn Féin. And just say, John, and I appreciate your attendance, it's just if I try and keep it to the time of 10 minutes, if that's okay, for each section. So you're on. Okay.
Thank you, Chair.
Yep.
And thank you very much, Bill, Mark, Claire and Arati for your attendance today. It's very important. I just want to take some time at the start to thank you for the work that you've been doing in this area for decades. I say that as somebody who has benefited personally from this, but also as somebody who lives in the community of Belfast and is very much aware of the work that unfortunately is needed now as much as ever. You'll be aware that the Chair has said that I have 10 minutes, so there are three areas that I would like to explore with you. The first being that this committee has done a tremendous amount of work in this parliamentary term from the time that Brandon Lewis made a statement in the House of Commons and the command paper was published to the passage of the legislation, and now unfortunately that we are dealing with a Legacy Act and no longer a Legacy Bill. I would throw it open to any of you really just to comment on the impact that passage of legislation has had on families from your point of view, and the impact that the cementing of that bill into legislation has had on families.
You know this on a day-to-day basis.
Yeah, well, it's had a tremendous and it's incalculable, the impact. It has re-traumatized families. In terms of preparation for this, and I kind of want to go through some figures because I asked some of our senior team to give maybe an environmental context of the scope of the work that we do. We employ 24 full-time staff. We're currently recruiting 4 more staff to bring us the complement of just under 30. Additionally, we have 20 plus staff that are contracted in sessional. That includes 2 clinical psychologists, a team of 12 trauma counsellors and complementary therapists dealing with anxiety and stress. We're registered with the appropriate health authorities and accredited to provide counselling and psychotherapy as a centre of excellence. In the last year, and it'll correct the figure in the document that we had in our opening statement, I was corrected last night, we supported 4,900 people. And I just want to give just a sense of a few things. The support we deliver is from several sites. across the north, and there's also remote support that goes on across the island and across these islands of people that have left the north who have been impacted. But to give you a sense of it, since this bill that has come about and the act that it is now, there's a total increase in referrals for mental health support of 310%. The total increase in suicidal ideation is 600%. And waiting lists for counselling and psychotherapy went from 6 weeks to 8 months. Now, this is not a trend that's unique to Relatives for Justice, who are supporting victims, but to all groups in the sector. And most people are citing the fact that hope has been taken away, that they've been asked and encouraged out by many initiatives, from Eames Bradley to Haas O'Sullivan to the Police Ombudsman's Office, the Historical Inquiries Team, all of those kind of agencies, and then the hope that the criminal justice system, with the devolution of criminal justice and policing and the appointment of Attorney General, thousands of cases. If you look, the Ombudsman had 450 plus cases that met the grave and exceptional threshold that warranted investigation, that constituted just over 500 killings. There was 1,100 civil actions lodged in the court. There are a number of up to 40 inquests. There are applications of around 60 inquests with the Attorney General, and that would continue. And that gives you a flavour, and 1,300 plus cases sitting with the PSNI's LIB. The shutters have come down effectively in all of those. They're finished, and that has left families in crisis, families re-traumatised, and families are describing it as a form of torture. This is what we call in term harm, additional harms on top of harms. So families that have been bereaved, people that have been seriously injured, promised justice using the mechanisms that have been provided through the peace process and the Good Friday Agreement and law and the rule of law to seek remedy and to seek accountability, have now just been taken away in one sweep. We sit in a jurisdiction in the Western democracy, a part of this jurisdiction where families who have had loved ones murdered have no remedy whatsoever. And that is having a huge traumatic effect on families. Anxiety, trauma, suicidal ideation, mental health problems. The repercussions of this bill it's hugely significant, and it's a hidden aspect of this while we focus on dealing with the bill, but the impact on families in their homes is colossal.
Yeah, and I think, understandably, I would imagine today's two sessions will deal a lot with the legislation and how the challenge has proceeded and what can possibly be done. But I think it is important to remember that in all of this, that there is a tremendous burden, which puts it lightly, on many families right across society. And it's important that that's on the record as to what they're facing. In the context of the legal case, again, I wanted to maybe explore about your view as to how the opening session went. I think I may be pressed for time. So what I will ask is that in your opening statement, and I think it dovetails well into what you've said about the burden families are facing. The opening statement makes reference to the fact that this is time families cannot afford. I noted on November 15th, Reuters reported in an interview with the Taoiseach, Leo Varadkar, in commentary around the interstate case, and what he said was that he wanted to stress that the initiation of an interstate case would be a very significant step and would have to be taken on solid grounds. It's not one which we would take lightly. And he goes on to say that based on the Attorney General's advice, there is a period during which we can take a case and after which it becomes more difficult. So we will have to make a decision on this in the next few weeks. Now, that was reported on November 15th. I would like your view on that. And again, if I don't get time to ask a further question, I will ask it now. And that is, there were 12 observations and criticisms about the legislation. There are some who will say that this is amendable. That voice may well come from those who are currently in power on either side of the Irish Sea. And I'm just wondering what you would say in relation to a piece of legislation, whether this can be fixed by amendment or what the alternative is. So I suppose my two-pronged question is the importance of an interstate case, and subject to correction from the chair. I think this committee has previously written, whenever the legislation was in bill form, urging the Attorney General to consider taking an interstate case. The importance of an interstate case, the urgency in coming to that decision, and also any comments that you would have about the amendability, which I think is a word I've just made up, but the ability to amend this legislation and perfect it that way.
Can I jump in quickly about the point, John, and about is this bill salvageable or is it redeemable? I quote the Northern Ireland Human Rights Chief Commissioner, Alison Kilpatrick, an eminent barrister and a specialist in Article 2 law. And she told the Northern Ireland Affairs Committee, and she's said internationally on many occasions, this is irredeemable. We believe that to be the case after taking advices from people at the United Nations, from people in leading academic fields in terms of experts on law. You can't fix this bill. It needs to just go. And in terms of taking the case, we would argue it's a humanitarian act. We talk about the impact on families. 5 years ago, on our database system of members, we had over 320 mothers. Today, there's just under 100 mothers left. This is time sensitive. Maureen Rafferty accompanied me to meet the Taoiseach Simon Coveney in Belfast when he was minister, and she said to him, "I'm pleading with you as an Irish citizen. I've been held on a string dangling for 2.5 decades of a promise of investigation, and it has never happened. And now this will take that away. I won't see the next 5 or 6 years by the time it takes to get to Strasbourg. I need you to intervene and act, because you will short-circuit that and you will go directly to Strasbourg with an interstate case. And maybe in my lifetime, if I live the next 5 or 6 years, I'll see some sense of satisfaction and remedy and accountability. Otherwise, I can't exhaust the processes of going through the domestic legal system to take a number of years. So it is an act of humanitarianism as well as standing up for rights and victims in the Good Friday Agreement. If that maybe quickly answers the question, if anyone wants to add to that.
Sorry, just to make it clear, there's a minute left in this section, just in case. So there's no problem, and we have 50 minutes left, and we'll give everybody the same amount of time. And if somebody doesn't take up time, we can get other people back in the second time. So if John, if you want to come back there.
No, I'd squeeze two rather large questions in. I don't know if anybody else, Bill, Clare or Addy, wants to come back in on the urgency of the Irish government, I think, making a decision.
Yeah, if they do, they can come back in maybe later.
Yeah.
It's just that, see, the committee, unfortunately, we set up 2 sessions back to back today.
Okay.
And that's the reason we have a time pressure, because normally we don't. So I'll take, it's Senator Neil Blaney is online, I think. Neil. He was earlier anyway, and if he's not there, I'll move on. He's not there right now. Okay, well then we're on to Fine Gael, so I won't take too long. I just want to commend the work that's been done, and I just have a few questions, particularly about your reference to the Labour Party and what they might do. And I think in the expectation that there may very well be a change of government, I think it's very important that we all engage with all of the parties in Westminster, but particularly the Labour Party and particularly with Hilary Benn. And do you have an understanding of what exactly they're saying actually in relation to the bill?
Well, they're on record as saying that they will reverse this bill. I think that in terms of asking for an interstate case, we're in a win-win situation, because if Labour does stay true to its proposal here and does reverse the bill, then, as I said in the open statement, a case in Europe would add pressure or support to that idea of doing away with the bill.
Just if it's helpful in relation to that our committee unanimously has written to and called on the government to actually take that interstate case. And obviously, clearly, there's a due process within government. And I recognise the fact, John, that you spoke about, I think it was the date in November the government made that statement. And the timeline is very short, and we'll be happy if the committee agree following this meeting to ask them, to urge them to actually take that case. But the key point is this, that I'm not clear, you see, if the legislation the present government are pushing that, I think the Labour Party aren't going to abolish it entirely. I think, if I'm right, they're talking about, and I think this is a key point, they're talking about the restoration and the continuation of the civil cases. That's the, the civil part of the legislation, which will be denied to people, to have an investigation, a coroner's inquest, and also I think to restore some independence as to whether there will be a prosecution or not. I don't know if that is correct or not, but what I think is very important is that we articulate to the Labour Party and other opposition parties in Westminster exactly, what the future might be if they're in power in relation to this.
Can I come back for just less than 1 minute? My other point was that if Labour does not go ahead with its promise, then the case to Europe becomes even more important. Now, I don't know if this goes against your opening remarks about respect and whatever, but I will say at a personal level that I'm not entirely convinced that Keir Starmer will be true to his word if and when he gets elected. And I am also not sure what space Hilary Benn might have, given what else is happening in British politics, to deliver on this.
No, I hear you on that, and that's why I raised the question. That's why I think it's important that those of us that are in political parties or that are in different organisations like yourself would renew, the presentation of our views and our opinions to people in opposition or who might be in government in the UK in the future. That's the only point I wish to make. The other point I want to make is that, and I acknowledge and agree fully with what you're saying, I have no issue with it, but I'm also concerned that people who would have committed murders and crimes on the side of the nationalist or the Republican community as well, what is happening there. And I would just appeal now, if I may, like the committee visited where Columba McVeigh was murdered and buried. His body has never been found. He's buried now over 48 years in a lonely bog, a huge bog in County Monaghan beside the border. And to talk to those families as well, which I know you do, but I just want to represent, our concerns for everybody who suffered, whose families were murdered by whoever they were. And do you have any view on that, on how you can make sure that the disappeared, whose bodies have not been recovered yet, what additional pressure we can put on, people who might know about those deaths and where those bodies will be found?
I would suggest that's your latter point there is beyond our brief about bringing pressure on military organisations, past or present. I would say that we absolutely, completely agree with you in relation to the families of the disappeared, because that in a way is a compounded difficulty they have. At least a lot of the families, most of the families that we deal with, would have had a body and would have a grave to go to, and they don't. I would just say, in conclusion on that there is no way whatsoever that this legacy bill makes those bodies more likely to be found.
No, of course it doesn't, but I think our discussion here today should put pressure on all of the people on all sides, to come clean with the things that have happened in the past. And I think it's important that we articulate, and certainly that I articulate, the views of the McVeigh family here today, because I feel very strongly about that, and I fully support. There's nothing that you said that I don't agree with, but I don't see any reference in your commentary, and perhaps I missed it, to those families, specifically, and I think that's a weakness from I see it as I think it'll be and I welcome your support for what I'm saying. And I just think that if we've to get peace in this island, we have to make sure, and I know that's what you want, is justice for everybody. So,
would you be happy if Claire and Mark both responded briefly to that?
Of course, yeah.
Thank you, Chair. And just to say that we in Relatives for Justice strongly believe that everyone harmed by the conflict needs to have justice and reparation. And in fact, all of our work has been about designing a process for that. And if I can just insert this one bit, one of the things that people in Relatives for Justice, myself and other people in Relatives for Justice, have been leading the way on is the notion of incorporating a gender lens for dealing with the legacy of the conflict. And one of the reasons we know that that is needed is that that looks at the multiple harms that people have endured from all actors. And we want any processes to look at all of those harms. And, you know, you outline the case of Columba McVeigh very eloquently, and not just the death of Columba, that the killing of Columba, but also his disappearance, and then what the family have had to endure. Now, that is replicated in so many ways in terms of not just one harm that is inflicted on a family, but many different kind of harms. Sometimes in one family there will be someone who has been killed by the British Army, and then someone who has been harmed by the Republic, by the IRA, or by other groups as well. So those kind of multiple harms happen in one family, and we want a process that looks at the harms of everyone involved, and we have always been very clear about that.
Yeah, well, I welcome that, and I agree with you. And the last thing I would say, and I move on then, I think, to Claire, if she's there, is just that, you know, like to not to have a body to bring home is entirely evil. And anybody who knows anything about that should come forward, and they can do it in a way in which they are not open to prosecution. And I just feel so strongly about that. But I accept and acknowledge your total concern and commitment to that principle. I think Claire Hanna, if she's there, please. Claire, she was there earlier, and I spoke to her. Okay, I'll move on to Frances Black then. Frances, you have 10 minutes, if that's okay. It's fine,
and I want to say thank you to all our witnesses for coming in today, but also for the amazing work that you're doing. I'm very aware of the work that you do, and it's really a vocation. It's your dedication, really, you know, is just brilliant. I suppose I have a couple of questions, firstly, I just want to say, you know, as Cathaoirleach said, the committee has supported the family's call for consideration by the Irish government on taking the interstate case, which is, we were really happy that we were able to support that. But I'm also aware that you've been recently in the US, am I right in saying that, meeting representatives of the administration and congressional representatives. So I was just wondering, would you be able to say a little bit? Would you be able to discuss the potential, you know, and what kind of reception did you get from the US? What did they say? Are they supportive of the interstate case? Could you say a little bit about that? And then I just want to come back then really to talk a little bit about the intergenerational trauma, if that's okay, Cathaoirleach. Thank you.
Thank you, Frances. Yes, we were in the United States just a few short weeks ago. We were invited to address this issue with the Irish diaspora. There are quite a number of families who live in the East Coast of the United States where we were, and I spoke at 4 events. We did a number of meetings. The Irish diaspora out there in the Irish American community, as you know, are central to establishing and helping get us the Good Friday Agreement, and they're very proud of that fact. This act effectively hollows out key provisions within it that our chair bill is referred to earlier. In the context of that, not only did we speak and update about what was happening, but we were rallying support for a lobby to encourage the Irish government. So we met a number of legislators and members of Congress and key aides. And the clear message from all of them was if the Irish government were to move to take this case, that they would support them fully, because they're very much aware of the the backdrop of this since it was introduced by Brandon Lewis as a command paper right through its passage the whole way into this law. And they too have been quite active and supportive of the families and their rights being afforded and protected in terms of proper effective investigations. So they're very vocal, they're very supportive. As my understanding that there is a letter circulating at the minute in draft form that I'm being told may emerge in the coming days or week in respect to directly writing to the Taoiseach and the Taoiseach, who we know have also engaged the US administration when they were last together at the UN in New York on this particular issue. So everyone's active on it. And I think what the message is that the Irish government has tried and did everything to the best of its ability. The UK have just continued regardless and ignored all of the pleas internationally from the US, the international community, and of course the Irish government. And if they are to act, I think they're encouraging them to take the case. And if I may just add to this, in 2022, the summer of 2022, we were very privileged to join with the Chair and other distinguished members of the panel, including John Finnick and Fergus, and we attended and we held a number of meetings on Capitol Hill around this particular issue, and we were very well received. And it was at that time that the Chair took the decision to say that if the government back home were to take an interstate case, that they were on record of supporting them. So all of that is encouraging, and I think we need to encourage the government internationally with as much support as it can get. They take this case, and we're urging them to do that. So thank you.
Thanks very much, Mark, and that's really good to hear. We all know the role that the US has played within the Good Friday Agreement. So I think, you know, the work that you're doing in the US is absolutely vital. So, yeah, thanks for that. I just want to come back to the piece around intergenerational trauma, and we know, I mean, you're dealing with it on a daily basis, the impact, you know, of what's happened in the North. We know it plays a huge role within the families, that ongoing trauma. I don't know if there's even a way to describe it. It's very difficult to describe intergenerational trauma, but the impact is absolutely horrific, and it also impacts culturally, politically, and economically in you know, in all sorts of ways. Families have and communities have, you know, huge emotional burdens to contend with. So I was wondering, can you speak about how your work and the legacy bill's attempt to curtail your work intersects with intergenerational trauma? Because I think that's very important.
Mark, can you take it?
I suppose it's reiterating what I said earlier. It's, you know, we have a generation following the peace process that hoped that this would be resolved. It's now past the new generation, and this act isn't a full stop. You know, it won't stop what's happening. It'll add to further destabilization. It's probably important to build on that. There's a number of parallels. This has a corrosive effect on the body politic in civil society. There's a lack of confidence in the criminal justice system. There's a lack of confidence in policing particularly, because the PSNI are fighting a rearguard action to protect the RUC in the Belfast courts. We've only to look at the Sean Brown case more recently, where 18 boxes of sensitive material were withheld, not only from the Irish government, who were involved in a panel around the Sean Brown murder with a number of lawyers to build confidence to have it resolved, but they withheld that from the Irish government, the police ombudsman and the courts, and it only emerged last week that this sensitive material is being retained by the intelligence services and the PSNI. And that could be replicated across case after case after case. Mm-hmm. So this has had a corrosive effect on all of that, where there is no support really for policing when it comes to these issues. That there's no confidence in the police to actively investigate or do anything, and they're fighting this rearguard action. You have that at one level. You have the intergenerational trauma now being handed to a new generation to pick up the baton, if you will, and to continue this fight, and that just passes it on. So the whole notion that this bill is branded as a piece of reconciliation is a complete lie. It's a complete falsehood. This will further the aim of trying to achieve reconciliation. It will cause more disharmony and dismay. It will cause more disillusionment. But the people driving this bill only care about one thing: the protection of British soldiers, the protection of their reputation in terms of their role in the conflict in our country. And that's really what's at the bottom of this. And as a committee, you will know yourselves, there's been other Oireachtas committees, and particularly the Barron inquiry, that sought to seek cooperation from the UK and the handover of documents, and they refused to cooperate with that. And this is in keeping with the whole modus of the UK in regards to how they approach legacy. So more generations, there'll be more trauma, be more intergenerational trauma, and all of the other associated elements that I've just described. And just coming back to the chair about we work with so many families affected by so many actors, and at times there's an attempt to pigeonhole our organisation in a particular way by other people that probably don't want us doing the work we're doing. And I'm not for one second saying that's what was being done this morning, but I'm working with quite a number of families who are being affected by the agent that was known as Steak Knife. And I've been working diligently for the past 6 years with quite a number of those families. And yesterday there was a decision made that be absolutely no prosecutions in relation to quite a number of those cases. In fact, Arati probably could talk about the impact the Ombudsman's letters had on families and the trauma that's been causing as well. So every day is a traumatic experience for families where they get the door closed on them after hopes and promises dashed. But you know what? There are brilliant people and there are resilient people, and they continue. And it's a privilege, and it's so humble to walk with them and support with them and work with them. And they've come through so much. And for this to be taken away from them through this act and to close everything down and to tell them, well, you're not going to get anything. That's it. It's over. Because this will not deliver. And it is irredeemable. You're not fixing this. And the beauty of the Stormont House Agreement was it was for everyone. All actors, regardless of who you were, if you were a victim, regardless of who the perpetrator was, this process worked for you. And that's what we had. And the UK didn't want it because they were subject to it as well.
Have we a chance to hear from you?
I've run out of time, but if somebody else wants to come in, and I'll come back in maybe at the very end for a final question. Yeah. But I think somebody else wants to come in there. Is it Claire?
Yeah, could I just
can I just, I'm happy
very
to take
briefly?
you. I'm happy to take you. There's no problem. Our problem is that we have just tried to ensure the number of members that want to speak to get everybody in. I'm going to let you in. Don't worry about that. It's Sinn Féin are next, right? I just want to get the order right, okay? And then, Paddy, you're after that. Is that okay? So is everybody happy with that?
Yeah, happy with that.
Yeah, no, that's fine. Just to make sure everybody can come in. Okay, so...
You can go ahead, Paddy.
And then if Claire comes back, or if Violet Hanwin, who is here, we'll make sure everybody gets in.
Paddy can go ahead.
Yeah, no, but I take this lady first.
Oh, yeah.
Yeah, sorry, yeah. And then I take Paddy. Sorry. Apologies about that.
Oh, don't worry. I just wanted to add very briefly to what it's been said already. As part of our work, we've been very active in reporting what's been happening in the High Court in Belfast. For 2 weeks, I think Bill mentioned the legal challenge that some of the families have taken. We are active in that sense, and something that the High Court heard, which I guess ties in with your question about the intergenerational trauma, is that the enactment of the bill, the act itself, it's considered to be a secondary trauma to victims and survivors. Now, that doesn't affect only to the initial victims, say. We are talking about a secondary trauma that now affects the whole family. So we are talking about different generations. Going back to previous questions, maybe that haven't been answered fully, we do believe that the Act violates several of the articles of the European Convention on Human Rights. But going back to basics, something that we don't mention many times, is that the basis and the core of all human rights is human dignity. And that's exactly what's been attacked, in this case, as a secondary trauma intergenerationally. So that's the impact across not only victims and survivors, but the whole society here. And I think that's something that we should also take into account.
Okay, thank you very much for that. Paddy?
Garby Margaret a Cahirig agus míle buchas díobse as an Carláthar thuirtún inniu. Thank you very much for the opportunity to discuss these issues with you here today, and to thank you as well for the hard work that you have been doing in your campaigns over the last number of years in relation to seeking justice as well. Obviously, the Legacy Bill is a devastating blow to people right across Ireland in terms of truth recovery and also seeking justice for their loved ones. And I think it's impossible nearly to overstate the heartbreak and the damage that bill is causing currently. And you know, it's a deep frustration that we have to see the British government operate unilaterally against the wishes of, you know, every single political party and community organisation across Ireland in relation to this. Obviously, Aontú has a bill. That bill is hoping to get into second stage soon, and that bill would mandate the Irish government to proceed with a court case in the European Court of Human Rights. So it would take the decision out of the government's hands, so to speak, and put it into the chamber as well. So we're hopeful that that might make progress over the next while. But I'd like to say here just today as well, I think it would be good if this committee passes a proposal today or a motion today that a letter would be sent to the Taoiseach and the Taoiseach, and that they would, we recommend and ask the government to proceed with that court case.
Agreed that.
Okay, very good, very good. Sorry, I missed that. That's excellent news.
No, I understand. Just so that you know, yeah. Which all the way.
Good stuff. And I suppose the questions I would have here for yourself is, why do you think that the Irish government hasn't so far taken a court case to the European Court of Human Rights? Why do you think there's a, let's say, a reluctance maybe in the government's circles in relation to this?
Okay, well, I make a stab at it. Just off the top of my head, a couple of things. Firstly, it's not something that's taken lightly. Secondly, there's some history of success, but also some history of failure in relation to such interstate cases. And thirdly, there may be what looks like a sort of genuine sense of saying, well, let's see, can this be amended? Let's see, can this be worked out just if we let it roll for a wee bit? In relation to that last one, we've already answered it, or Mark has already answered it. It is not redeemable. So I would say that, you know, despite the complexity, despite the gravitas of bringing such a case, and despite past failures, it has to happen. It simply has to happen, because it's the only way forward in terms of trying to stop this bill or stop this act continuing to cause harm.
Okay, I always felt that the Irish government have a reluctance, because I suppose the governments here have had an instinct that, you know, they should operate within the bounds of diplomacy, and that diplomacy is the best way to try and get the British across the line in terms of change. But you know, it strikes me that you know, that unilateralism, which is at the heart of the Tory government at the moment, is impervious to diplomacy. In actual fact, when we saw the European Union threaten to bring Britain to court over the Brexit issue, it very quickly changed the British government's direction of travel on that issue. So the British government, I don't think, understand the subtleties of diplomacy, only understand the stronger engagements such as court cases. We've been looking at a bill and produced a bill which would give an opportunity for the Southern government to initiate a commission of investigation into the South in relation to murders that were committed in the north of Ireland in terms of the British state, and murders that were committed in the southern states, such as obviously the Dublin Monaghan bombings, etc. Because obviously, I suppose we're trying to find justice where we can get it. The particular commission of investigation that we're looking at would allow for, obviously, evidence to be given to a judge in the southern jurisdiction. It would allow people from the north of Ireland also to provide evidence. It would allow also that evidence that was collected in reports in the north and elsewhere in terms of state violence, especially, would be included in the investigation. So, for example, the police ombudsman in the north of Ireland has carried out some very good work in terms of killings that have happened in the north, and they could be included into an investigation that was located in the south of Ireland. Now, obviously, we wouldn't have the ability to subpoena people outside of the jurisdiction, but such a commission of investigation still would actually offer a great opportunity for the collection of information and also for that information to be analysed, for a decision to be made in terms of responsibilities for state murders. What's your own opinion on such a project?
Peadar, in general, we are not like you. We're not elected politicians, and while I personally may have opinions, and I could let fly with them of what I think of the Tory government in the UK at the moment, I won't do that. What I will say is that if you can contribute to, in any way, from either side of the border, to bringing more truth to bear in relation to what happened, organisations like RFJ would be completely behind you. And not to negate that, I would say that there are two other things that you have to add to it. Firstly, there is an awful lot of information there already, right? And secondly, there's an awful lot of information that we know that's there already, but we haven't actually seen what it is. And Mark was referring to some of that earlier, or sorry, I was in my initial report about what was buried at Kew. But remember, there's also stuff that's potentially available in the southern system in relation to Dublin Monaghan, for example, that has not come to light. And whether it comes to light through such an investigation or any other way that you can, that would be welcome, because truth is not the same as justice, but it's part way there.
Okay, Gurb Margaret. And just is there? Can you identify or where the blockages are in terms of information travelling that is in the hands of the southern authorities, whether it be the Garda Síochána or the state? If they could be identified very clearly, it would give us an opportunity as elected representatives here to really push for that to happen. So maybe it wouldn't be possible for that information to be given now, but maybe that you might provide elements of blockages that might exist for the transfer of information at a later date to the committee, and the committee might start to work on trying to free up those blockages as well.
Fair enough. But also with respect, you're on the spot, so keep digging.
Okay, okay. Good stuff. Listen, I wonder, is it possible just to ask a number of questions in relation to the bill itself, or the legacy legislation itself? I just have some queries on that you might be able to answer. Just in a situation where a person provides an account of which is true to the best of their knowledge or belief, and then is disproved in evidence, potentially later, in those situations, can immunity be rescinded?
Mark?
It's my understanding, if they're found to have lied, that it will be rescinded and there'll probably be a sentence. But the problem with this legislation is that, in our experience in dealing with legacy over a number of decades, is that this will favour one set of actors only. And there'll be those who wore a state uniform, or those who were employed by the state within illegal paramilitary organisations. I have spoken down the years to a number of police officers that worked with John Stevens, who investigated collusion over 3 inquiries. He did tell us, John Stevens himself, he told myself and a lawyer in Belfast, that of the 210 people he arrested during his inquiries, his extensive inquiries, which were the largest police investigation in British history, and this part of the jurisdiction falls under that, that it was the largest police investigation in British history, only up until the point of the 7/7 bombings in London. But he did say of the 210 people that he questioned under caution as voluntary attenders or else under arrest, that 207 of them were participating state agents within paramilitary organisations. Now, his report has never been published. The Stevens report's never been published. And I think that gives us an estimation of really what's at play here. And what the UK government have done is they've looked at this big macro picture And as Bill rightly pointed out, they've put all the underhanded tactics of hiding evidence, burying evidence, concealing evidence, destroying evidence, hiding witnesses, prevarication and delay and obfuscation. They've brought it all into this act. And if there are beneficiaries of this act, it's principally those who wore the state uniform and those who worked for the state. I have a concern that then we go into a territory where this legislation itself could be weaponised and used in a political way that is very dangerous for political advantage and to preserve a particular narrative of the conflict that accommodates a British view of the conflict. And that's really what's been happening in the courts with the destruction and the hiding of evidence. So it would really continue in the same vein. So they made amendments that anyone that refused to cooperate or was requested to cooperate would be fined up to £5,000. And if their review found that there was wrongdoing and there was evidence of it, they would serve their full sentence. And anyone that came along, and as you say, that the threshold really equates an amnesty to the best of your knowledge. Well, the most commonly used phrase during the Bloody Sunday inquiry was, "I can't remember." So that's the territory you're in, and it's the commonly used phrase behind screens of British soldiers in Belfast courts. So really, there will be, if there's punitive elements in this bill, it'll be weaponised to promote a state narrative and to agitate and go against people who were non-state actors, and that's a completely dangerous territory that I fear about this act as well.
One final tiny question is, and you may have discussed this earlier, but I missed the start because I was elsewhere in the chamber, but is there a deadline in which cases can be brought in relation to this bill to the European Court of Human Rights in terms of individuals or the state?
Well, I think the 18th of September is when the Act was passed in the UK Parliament. My understanding, speaking to some lawyers, is that you have 4 months to lodge the interstate case. So that brings us to January 18, and we have a ticking clock. We've 2 ticking clocks. We've ticking clocks in Belfast where the state is refusing to hand over information to coroners and running down the clock to May 1st, whereby inquests will be shut down and won't be concluded because of that. And we've the ticking clock for the Irish government to make up its mind whether or not to take the case of January 18th. And that's where families are stuck between right now. And if you can appreciate, it's not a good place to be. And hence, this is our last hope and last option that the UK Act is challenged by the Irish government. It was mentioned earlier about will they take it? Well, and Bill rightly says these are not decisions you take lightly, but ultimately, this is the voice of all victims in the North, whether you're the disappeared, whether you're affected by Republicans, by loyalists, or by the state, whether you're combatants that were affected, whether you're civilians, which is the majority of people. We're all saying we oppose this. We're all saying we don't want it. We're all saying that Stormont House, there was a better consensus around it. It would work. It was inclusive. And we're all saying to the Irish government, and I am talking to unionists and unionist victims on a weekly basis, and they're saying we all want the Irish government to take this. And I think there are communications privately by a lot of those victims and some organisations to say, yes, they should take it. So we've got until the 18th of January, and we're saying it's the right thing to do. You have a legal and a moral objective to do it, and we're encouraging and urging you to take the interstate case. It's the right thing to do.
Okay, thank you very much.
Yeah, I just have a question. I wasn't aware the deadline was the 18th of January, actually, and that is very worrying, I have to say. And I don't think, I mean, I think it's really important that the Irish government make a decision as soon as possible on this issue. I suppose I just want to talk a little bit about the Good Friday Agreement. We know that the European Convention on Human Rights is the scaffolding of the Good Friday Agreement. I suppose, how do you feel the passage of the Legacy Bill, which is so obviously a violation of Article 2, will impact the Good Friday Agreement? I mean, it's one of the most important agreements, you know, ever. So I think it's really important to kind of talk a little bit about that. And then do you have any views on the debate within the Tory government, and maybe this is something that, you know, you don't really want to speak on, but, you know, I'm just wondering, do you have any views on the debate within the Tory government around leaving the jurisdiction of the ECHR so they can harden their immigration policy? And does that link in some way, or is there a connection, or what's your thoughts on the connection around all of that?
Okay, it is a bit beyond our brief, but I'll give you some reply to that. I do believe that the current Tory government does see international human rights law as an obstacle rather than as an opportunity. Mm-hmm. And it shows in various forms, and the most obvious one, Francis, is the one you've just raised in relation to migration. Mm-hmm. If you remember, when the Supreme Court there recently slapped down the legislation in relation to bringing refugees or asylum seekers to Rwanda, the immediate response of the UK government was not to say, "Oh yes, we do acknowledge our international human rights obligations," but was to say, "Let us design a piece of legislation that human rights organisations, international human rights organisations, can't stop us doing it." Now, I don't know what that means, but ultimately, the logic of that is to say, let's pull out of all these international obligations. And I would say that no one, to my knowledge, has said that specifically in relation to the Legacy Bill and the Legacy Act. I may be wrong, Mark, you might correct me. But I think that there is a logic in there that says, okay, we can fix it, make sure that it's human rights compliant. We disagree entirely with that, and we've got a lot of support for that. But if it keeps on being shown that it can't be made human rights compliant, it's only a matter of time before I think some Secretary of State or some other Tory minister said, well, okay, let's do it. Let's do it anyway, because we don't want to be encumbered by human rights legislation.
Yeah. And then I'll just come to yourself again, Bill, while I have you, just with regard to Keir Starmer and why you think he wouldn't stick to his word. I think I'd like to hear a little bit more about that when it comes to the Legacy Bill. I think that's important for us because I think it means that we here in Dublin have to put huge pressure going forward on the Irish government, even more so. Do you know what I mean? So can you just say a little bit about that?
Francis, I'd prefer to be talking to you about this over a pint at Fela, but in the meantime, look, without getting too deep into this, I think that the priority of both the Labour and Tory governments in England at the moment is how do we get elected? Yeah. So it's not about how do we make the country better, or how do we solve this huge problem, or how do we improve the economy. It's about none of those things. All of those other things fall in under the one rubric, how do we get elected? So as far as, for example, Suella Braverman is concerned, and James Cleverly and others aren't so far behind, it is how do we stop the boats? So that'll get us elected. If we can stop the boats, if we have an act that shows that we're going to stop the boats, then we'll get elected. I think on the side of the Labour Party, how do we get elected leads to one answer, and that is, and again it's the boat metaphor, don't rock any boats. So be as middle of the road, somewhere between, I don't know, between Thatcher and Blair, because that's where the votes lie. Don't rock any boats. Don't promise anything that's going to be a hostage to fortune. Be as bland as possible, because bland is what will get us elected.
Okay, thank you.
I wouldn't disagree with that analysis. I think we've had a very good engagement with you. Is there anybody from Sinn Féin MPs? Are they there? I think.
Chair, can I just?
Sorry, John,
I just want to make a. Yeah, I think you were the first to make the suggestion about a further letter. I think for me, as the conversation has progressed, what's clear, respectfully from my point of view, is that there needs to be two aspects to that letter. Firstly, it needs to stress the urgency and that a decision needs to be made. We're aware now of the time frame, but the government since this committee has first written to the Attorney General, I believe, had formed the position that they wanted to wait and see what the legislation looked like in its final form. Well, we now have that. The Taoiseach is now nearly a month on record as saying that the position will be published within a matter of weeks. We know that there is an urgency. I don't need to rehearse the reasons that our guests have set out this morning. So I think it needs to set out the urgency and also repeat the position of the committee, which is that the case needs to be taken for all of the obvious reasons. So I just wish to make that observation. There's just one very brief follow-up question that I was going to ask, and that is the timetable for the challenge. The oral evidence, or the oral submission, sorry, of the judicial review concluded last week, as I understand. Our next guest may well be getting into that in a little bit more detail, but I'm just wondering if anybody can outline the expected time frame that these legal challenges will now face, in the realistic expectation that either side will appeal this through all of the challenge.
Can I maybe pick up on that? And I know, Arati, you were in the court for the 2 weeks and observing and monitoring with families. Justice Colton heard that case, and I don't believe a verdict of a case of that magnitude and the amount of papers. And I know the next contributor is very centrally involved in the case and is representing families and initiated the case in part. But I can't see a judgment being delivered before September 18. January 18, which is the deadline, and an appeal will take place by either side, as we have pointed out, which will go to the Court of Appeal. Then it'll go to the UK Supreme Court. The way the British government have prevaricated and obfuscated and delayed the tactic, you could be a few years, you could be 3-4 years before you get to Strasbourg. The beauty of the interstate case is it leapfrogs all that and goes directly, and could be within, I believe, possibly the Grand Chamber within a number of months. There'll just be submissions from both sides. There'll be merits to the case going forward, and then it will go forward and be heard. And that's really the ballpark that we need to be in. And the other important thing that we probably need to understand about this is an act in British law. A British court can only make a declaration. It can't overturn it. A British court can only make a declaration of concerns about its incompatibility with the European Convention on Human Rights. Beyond that, it can't do anything else. It can't overturn it. So that is, but it's important that it's taken, and it's important that the stand is taken and families battle that. But it's important that this is heard in Strasbourg as quickly as possible. Arati, if you want to add to that.
Okay, so we have.
Thank you, Chair.
Just arrived. Pardon?
Sorry, I was just saying thank you, Chair. That's me.
Okay. Francie, you're okay. Do you want to say anything? Are you okay? No, fine. Okay, well then we've had a very interesting debate. I think, Mark, we met in Washington, and we met a person by the name of Martin Galvin on the AOH. I know John was with us there as well. Well, his organisation are taking this whole debate today online, so we send our good wishes to all the AOH people in America who have the privilege of listening to our wise words. But I just want to say it's been very important and informative, and I think collectively we all agree, A, that the case should be taken, and B, that this committee should write, if that's agreed unanimously. And John, I don't think there's be anybody who disagree with the sentiments and what you suggested there that we should say. So I'll ask the clerk to circulate a draft letter to everybody so we're all agreed with it, and I don't see any reason why we won't be, and we'll get it off to the Taoiseach and the government straight away. The second thing is that thank, if I can use first names, Bill, Claire, Arati and Mark for your attendance here today, and I think we just need to maybe, as you say, keep on top of the issues and debate them, and our communication and the additional knowledge I have today and our members as a result of your contribution has been very welcome indeed. So I'll adjourn this meeting now because we have a second session in a few minutes with a different group, and I want to thank you again for coming to us, and I know, please God, we'll meet you all again in the new year. And thank you. So this committee is now adjourned, suspended till 11 o'clock. Thank you. Okay.